Anthony Rico, is that what I got next?
Let me go grab him, Judge. We had to remove him. It'll be one moment.
There's always one. All right, Anthony Rico, a criminal trespass. All right. All right. Mr. Rico. Are you Mr. Rico?
Yes, sir.
Good afternoon. My name is Walt Weaver. I'm the judge of Potter County Court of Law number 1. I'm going to be hearing your case today. I've reviewed your plea papers, Mr. Rico. It appears to me you're ready to waive all your constitutional rights in exchange for a plea bargain agreement. But you do have an absolute constitutional right to appear in my open courtroom and face your accusers. Or you could also choose not to use that right as well and agree to appear by video. Are you agreeing to appear by video?
If I can, man, you can just like figure it out in court and I guess.
Are you saying you don't want to do this on video?
I'm not trying to be in court hearing and doing stuff on here. I just ain't got
Mr.
time.
Rico, it's real simple.
I don't got time to be here, man. If you can, just do your job or do whatever you're doing or something, man. But I don't really care what you do, man.
I'd love to do my job, but part of my
It's not
job
my
is
job, dog.
sure
It's not my fucking job, all right? I don't give a fuck what you look like. You know what I'm saying? Your job is gay.
Adjourned. I'm going to hold you in contempt.
Hey, bro,
do we need to preserve this as evidence now since that's resisting? All right, don't delete the YouTube video. That's unfortunate. Hey, Ethan. Keep them coming, man.
I apologize, Your Honor.
Oh, it's not your fault. That's part of our part and parcel. Boy, he's so little, and look how much people he's got. Could you please put him, Miss Morris, on a transport next time so we can get it done? Boy, if that's not the funnest name I've said all day. Man, it's too bad Mr. Rico could have gone home today. He decided he'd rather stay.
You might have got a new prosecutor today.
Well, it's all live. You saw him fight the deputy. Technically, he's under arrest in a jail. Do you have to prove that element?
Before we even press play, let me set the stage for you. Because today's courtroom chaos is a masterclass in what not to do when a judge is trying to give you a chance. We've got two very different defendants, but they share one fatal flaw. They both have the right to remain silent, and absolutely no ability to use it. One man is literally on the verge of walking out the door, possibly going home, and instead chooses verbal self-destruction. The other? He strolls into court from home, talks himself into deeper trouble, and casually hands the prosecution admissions on a silver platter. This is one of those hearings where you can actually see the moment everything falls apart. The judge starts calm, professional, even patient. And then, ego, emotion, and impulsive talking take over. Watch closely, because in both cases, the law isn't what hurts them. It's their mouths. Let's get into it.
Please, for the record.
Mark Briggs, 10/3/1964.
Mr. Briggs, you're before the court today making first appearance, Raymond, on 2 charges. The first is malicious mischief in the 3rd degree. It's a gross misdemeanor subject to 364 days in jail and a $5,000 fine. Second is harassment, domestic violence. That's also a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. Because the charges have domestic violence enhancements, they are something where if you're convicted of them, it would result in your inability to possess firearms.
I don't own a firearm. That's
okay.
what I told
Again,
you.
I have to let everybody know whether you have guns or not. Because these are criminal charges, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today, sir, for a court-appointed attorney?
No, sir. I'll be getting mine.
Okay, sounds good. So enter a not guilty plea today.
Yes, I do have something I want to add, though. I was denied due process.
So if you have an attorney, or going to hire an attorney, your attorney would probably have you exercise at this point your right to remain silent.
I don't want to exercise my right to remain silent because I have nothing to hide. So I was denied due process. I have paperwork that proves that I owned the car before I was married. So therefore the car is mine. And since we're in separation, no judge has divided property yet. So technically the car is still mine. So I wrote on my own car. That's a fact. Here's the paperwork. I
We're
sit
not
down at
having
the
a
bank.
trial today.
Well-
We're having your arraignment.
Okay.
You're entering a not guilty plea.
I was denied
You've
due
told-
process.
The judge hasn't even gotten into the substance of the case yet, and there's tension. Notice how routine everything starts. Confirmation of identity, explanation of rights, procedural housekeeping. This is standard courtroom rhythm. Calm. Predictable. Structured, and here's the important part. The judge is offering something many defendants would gladly accept. The option to proceed by video or in person, while reviewing plea paperwork that suggests a negotiated agreement. Translation? This might have been simple. Possibly even favorable. But when someone walks into court already irritated, impatient, or dismissive, that calm structure can unravel quickly. Watch what happens next, because this is the fork in the road moment. One answer keeps this
Denied all kinds of rights, and I will be coming back with a vengeance. I have
Are you
paperwork.
threatening the court?
I am
sir?
not threatening the court anything. I'm not threatening anybody.
You just-
I have the
you
right
said
to
you
sue.
were coming
I have
back
the
with
right,
a
I have the
vengeance.
right to sue this city, and that's what I just said. So if you want to take that farther than that, that's up to you. I did not say that. I'm
You
making
said
it
you are
clear.
coming back with a vengeance.
With an attorney.
On
It
the
doesn't have
record,
anything to do with me. That's not a threat to you. The city. I said I'm suing the city. So you do what you want today. Go ahead and hold me in contempt. Go ahead. I'm suing the city. I will be suing the city. If you will take that as a threat, then that's fine. I will be talking to the city attorney. I've already talked to the city. I'm talking to people. I talked to the police chief already.
Yeah, I've seen how you've conducted yourself. so
Yeah,
far.
that's right. Because I'm being wronged. It's my house. She had no business being there. And she hasn't even lived there for 6 months. She hasn't paid a bill for 8 months. She can't just come there. I have rights.
You do?
Just because she's entitled to
So
be
again,
able to
we've-
be on the
again, we've
property
talked
doesn't mean
about-
she can just come.
We've discussed your rights today. We're not going to litigate your case today.
Do I have the option to
This is-
speak with the city attorney
This
as
is a
well?
criminal court.
Do I have the option to speak with the city
Not once
attorney?
you say you're going to be hiring an attorney.
that comment. He could have gone home today. That's not sarcasm, that's insight. There are days in court where things line up in your favor. Plea paperwork ready, procedural boxes checked, judge prepared to move forward efficiently. But courtroom outcomes are fragile. They depend on cooperation, timing, and behavior. When the judge jokes about a new prosecutor, that's subtle courtroom humor, but it carries weight. It suggests opportunity was there. And it vanished. The defendant didn't lose on legal complexity. He lost on impulse control. Quick question for you watching. How many times have we seen cases where the charges weren't the biggest problem, the attitude was? Drop your thoughts below. Because this first hearing is a perfect example of how conduct can
But we do have some release conditions we will be requesting.
Okay. Go ahead, Ms. Carmen.
Yes, Your Honor. We are requesting a formal no contact order with victim notification.
It should have been me filing.
Both.
She's
Please,
harassed
sir.
me.
Please, sir,
All right, go ahead.
the facts of this case are highly concerning with regard to the threats that were made. These folks are in the midst of a dissolution. Statistically, through peer-reviewed literature, that is one of the highest risk times for partners who are splitting for domestic
Well, what about the
violence.
time I got punched in the chest 5 times? Nobody did anything about that, and I reported it to the officer. Upon arrest, I told him 2.5 months ago, I've been punched in the chest. I will take a lie detector test for that and pay for it. And I received
At this point,
nothing.
the city attorney is making her release recommendation. You need to let her finish.
I was denied due process. You guys didn't take my complaint. So you didn't even take my complaint. And then you don't want me to call it racism. You didn't even take my complaint.
The only thing we are doing today, sir, is you have entered a not
Well, there
guilty
should be
plea.
equal treatment under the law, and I have not
We're not
received it.
litigating your case today. I've already told you that. You've seen every other person come up here. I've entered not guilty pleas. I've set
Well, I
release
want to put this in the record is, can I give this to the attorney so she can follow up on this? This is my proof that the car is mine. There's been no dissolution. No court has divided property.
So would you like me to continue?
Yeah.
So again, we are asking for the victim notification. There was an ex parte no contact order approved in Clark County Superior Court this week. However, as of yesterday, it had not been served, so there is not formally protection in place for the victim.
I don't go to her. I am at my house. She came to me. I never go to her. So why is the order against me when I don't even deal with her?
Please let the city attorney finish her recommendation. So we're walking on a very fine line right here with your conduct in court today.
Okay, I'll stop. Sorry.
Thank you. Go ahead, Ms. Carmi.
So yes, Your Honor, and while there's no in-state prior history with domestic violence, there is a older mid-1990s arrest for assault 4. So there is some history there. We think all of the circumstances in this case, particularly with regard to statements of harm to the victim at this time, warrant that victim notification.
I don't even go to Oregon, sir.
I will
She lives in
add,
Oregon.
I will add, because Mr. Briggs has brought it up, we are not seeking to remove him from the home that he is residing in.
How you gonna, she don't even live there. Are you kidding me? She doesn't live there. I paid the mortgage there for the last for 4 years. I paid the mortgage, and I can prove that.
Mr. Briggs.
I'm trying.
Right there. Did you hear that? I wrote on my own car. That statement might feel harmless emotionally, but legally? That's an admission tied directly to the charge of malicious mischief. Whether he believes the property division favors him or not is irrelevant at arraignment. Ownership disputes get decided in civil proceedings, not by casually narrating facts during a criminal hearing, and notice the judge's patience. He's not arguing property law. He's reminding him, this is not trial. This is arraignment. The purpose today is entering a plea, setting conditions, and preserving rights. Every extra word spoken here creates record. Record becomes evidence. Evidence becomes argument. This is why attorneys constantly tell clients, stop talking. Not because you're guilty, but because facts should be strategically presented, not emotionally
And by so that she can go get her personal belongings from the home.
Property has not been divided by the court. She has her personal items and her personal belongings. And then the court has to divide the property. That's what I've been waiting for. I've encouraged her to file the divorce papers, sir.
I will be finished here shortly, Your Honor. The proposed NCO that we have drafted, after contacting Battleground to make sure this is something that they could do.
That's against the law. No way.
Is that she can call for a civil standby where they would go to Mr. Briggs' home. She has the same 15
She
to
can't
20.
come there and just take whatever she wants out of the home. It hasn't been divided by the divorce court. I don't have a problem sharing, but it's an argument every time.
So one of the things that you've brought up, Mr. Briggs, today is that there was likely separate property, it sounds like, prior to your matrimony.
Yes, sir.
My assumption, and I could be wrong, my assumption is that the other party also had separate property prior to the matrimony. So yes, you are right. The court, if the property is shared property, the court certainly cannot order a person to go in and take shared property. You are correct on that. The court, however, can, if there is separate property of hers in the residence, allow her to retrieve separate property.
But she's taken my property. That's the reason why I don't want her
I
in the
don't know what
house.
she's going to do. We're talking about prospectively, sir, not retroactively. When she shows up at your home and takes her separate property, that would be allowed. Do you understand?
That's actually not allowed. Sir, she didn't even have any place to put the stuff. She's in a bedroom at her mom's. Now, she can have the kitchen table, which is hers. I don't have a problem with that. I've held nothing from her. I don't want to fight. The reason why we have not been around each other is because of what happened the other day. I didn't want that to happen. I've made many statements to family and relatives that I refuse to be around her. I believe she's demonically possessed by the Jezebel spirit. So I don't want her around me. There's a visceral reaction that I haven't felt around a person in many years. If I'm from here to her, I want to throw up. I literally cannot be around her. And I've required that she not come to the house. She came to the house because I refused to get the HELOC with her to help her pay off her bills. So she came to the house the next day, and then that's when everything started. I was sitting there with my brother-in-law, drinking beer by myself like I always do. I didn't go to her. She came to my house. And she has forfeited, I haven't proved it, but she's forfeited her right to the property. She hasn't paid a single bill there in 8 months. And when she left, the moment that she took her and got a new bank account at Columbia Credit Union, that's the day of separation. That was over 8 months ago. She cannot just come to that property. She cannot.
So, Your Honor, I have, if you do adopt it, change the language in the civil standby to indicate that the law enforcement agency would assist the protected party in obtaining personal belongings.
She has her personal belongings, and not only that, she stole every picture off the wall, which she was not entitled to. She stole all of our financial records, which she was not entitled to all of it. So now I'm in a position when I do go to court to battle her, all the financial records are in her possession because she stole them out of the house. But when I got arrested, they wouldn't even let me go and secure my home or give them any instructions on what to do.
Territory. Coming back with a vengeance might sound like frustration, but in a courtroom, especially in a domestic-related matter, words matter. Judges are trained to assess risk. Prosecutors are trained to document tone. When someone references vengeance during a case involving alleged threats and domestic violence enhancements, that phrasing doesn't land well. And notice the judge immediately clarifies, "Are you threatening the court?" That's not overreaction, that's risk management. Here's the irony.